It's a great pleasure to be here to welcome you to this Eminent Speaker Series event. As Serena said, my name is Robert Cunningham, the Dean and Head of Curtin Law School, but also a barrister within Murray Chambers and the National Law Lead of the Digital Finance Cooperative Research Centre, and that's a discussion for another day. Nala karich nunga mo, kan karich nijibuja. Nan karich nunga, kabli, brr, kuriye. And of course, I don't profess to have any specific expertise in matters related to Noongar, but to make the point that that the Noongar language was perhaps the most spoken Indigenous language in this country, in the southwest with the 14 clans. It covers a very large area of Australia. So with respect to this building, I think many of you will know that between World War I and World War II, A.O. Neville was responsible for administering the stolen generation policies of this state. And so today we have the Western Australian Stolen Generation Alliance working to heal some of the damage that flowed from those particular policies. I'll also draw attention to the fact that we're in the Noongar season of Makaroo, which is obviously a very cold and wet season. And today is also solstice, or at least last night was perhaps the longest night of the year. Also just wanted to make mention of The Voice and to indicate that I will be voting yes for The Voice, and if you want to know why, I'm happy to have a conversation with you after this event and provide my reasons and rationale as to why I'll be supporting. So the Curtin Law School has been around for 10 years. And during that time, we've had many eminent speakers come to visit. And I won't go through all of them, but just to give some examples, we've had Chief Judge Julie Wager from the District Court come and present. We've had the Honourable John McKechnie, the Commissioner of the Corruption and Crime Commission. We've had Justice James Edelman, who's of course on the High Court. And indeed, we've had Malcolm McCusker, AC, CBO, KC, who also gave an eminent speaker talk in 2019 with respect to Andrew Mallard. And not all, but many of you will know the story of Andrew Mallard as a wrongful conviction, as one of many examples in Western Australia, where he spent 12 years in prison, so very relevant to today's talk. So of course, Malcolm McCusker will be known to many of you as both a barrister and a philanthropist, but also as the 31st Governor of Western Australia. He has been the Chairman for Legal Aid. He has been Senior Counsel in a number of high-profile cases, including the one that I just mentioned concerning Andrew Mallard. No longer a Queen's Counsel, but now a King's Counsel, which is a mistake we can easily make now, but a life member of the Law Society of Western Australia. So Malcolm's going to say a few words to frame this event, and then I'll come back up and introduce the Vice-Chancellor, and we'll take it from there. Thanks, Malcolm.
Thanks, Robert. You mentioned the Mallard case, and you mentioned Professor, as he was for a while, James Edelman, now on the High Court. You might be interested to know that he was my junior when we took the Mallard appeal to the High Court, so it goes back a long way. I've been asked to address you briefly, I stress, on the importance of this particular subject of wrongful convictions, because some people, even today, say, well, are there that many wrongful convictions? Is it really worthwhile studying what happens in those cases? I think it is. Justice Corey of the Manitoba Court years ago, and I often quote him, said, there is much damage done to the administration of justice and our community as to the individual prisoner who's wrongfully convicted. It's a nightmare to all free people, and it's not to be tolerated. Now, what's the incidence of this? Well, there's been various estimates of how many people, innocent people, are in prison. There are some put it as high as 5% of prisoners are actually wrongfully convicted. So Thomas Thorpe who you probably know, Harlene, New Zealand, former prosecutor and former Supreme Court judge in New Zealand, estimated that there were up to 20 innocent people in prison. That was an estimate made in 2006, so it's unlikely that the numbers would have dropped. And in the United Kingdom, the CCRC, the Criminal Case Review Commission, which they have there, which I think we should look at, and I'll mention it later this time, has referred a number of cases of alleged wrongful convictions to the Court of Appeal. It acts as a sift because it only refers a fairly small number of those who make application to the Commission. But as of the last count, there were over 480 matters referred to the Court of Appeal by the CCRC, which resulted in the reversal of murder convictions. 480 people had been wrongfully convicted. Of those, incidentally, because it went right back, 3 of them had been hanged. So it wasn't much use to them, but it was their relatives, of course, who had always protested that their relative had been wrongfully convicted. As apart from murder convictions, there were over 100 rape convictions and many others which have been referred. So there are good reasons why we should look closely at the question of wrongful convictions. I've been asked to refer to some of my experiences in that area. Well, I'll tell you, there are 3 cases that I personally know of, which I'm sure resulted in wrongful convictions which have never been reversed. One of them, a man called Greer, was convicted of murder of a young girl in Glyde Street, Mosman Park, Western Australia. He was convicted on the basis of circumstantial evidence. Now, I think the Curtin Law School had an Innocence Project way back, which looked into that and came up with some pretty strong evidence to show that the evidence given at Greer's trial was flawed. Sadly, he's now dead. There's been an ongoing agitation on the part of the group supporting his reversal conviction, but now that's really faded, I think, although some still think perhaps they could get a wrongful conviction reversed even though he's dead. There was another case, I didn't act for Greer, I just looked at the matter when in fact the Innocence Project came to me to discuss it. Another case, a man called Rinaldi, who's still in jail. I am absolutely confident that he's been wrongfully convicted of a murder based entirely again on circumstantial evidence. Now, circumstantial evidence, of course, can be very good evidence, be strong, but in this case, the circumstantial evidence didn't really stand up. But the problem with that case, I took it on appeal, didn't do the trial, and I must say, quite frankly, one of the problems with his case was his counsel. And so one of the grounds of appeal was incompetence of counsel, which is a very hard one to win. But his counsel, at the end of the prosecution case, came up to him and asked him to sign a paper saying that he was prepared not to give evidence. Now, it was out of the blue, and he didn't give evidence. Not giving evidence is a very risky thing, particularly in a circumstantial case. And there's another case, a case of rape, which I'm quite confident was based upon evidence from a young woman, his daughter, who had been suffering from all kinds of trauma, and there's no doubt that she had this revived memory thing. Indeed, after he'd been convicted, the daughter arranged to see him in prison and said to him, "I'm not sure whether what I said had actually happened or whether because she'd been seeing counsel." And Harlene nods her head at that because that's the kind of thing that can happen. When she gave the evidence at trial, she was very convincing because she believed it. But to me, it just seemed extraordinary that what she described could have possibly happened. And she acknowledged that perhaps it was just a kind of revived or implanted memory. So how do wrongful convictions happen? Well, I acted for years for 2 brothers, Mickelberg brothers, you may have heard of them. They were convicted of mint fraud, and they were convicted essentially on the basis, not entirely, but essentially on the basis of confessions. In those days, you could have, police could give and did give quite frequently evidence of what they called verbals. That is, you didn't have to have a signed confession, you just have to have two police witnesses who would say, this is what he said, and I wrote it down carefully, question, answer, question, answer. This went on for a long time. We took several appeals on other grounds, such as false evidence or incorrect evidence of fingerprints. We went up and down to the Court of Appeal and the High Court twice, and eventually, once one of the detectives who'd given evidence as to the confessions died, blown up by bikies actually, a fellow called Hancock, and because they didn't like the fact that, we won't go there, blown up by bikies, not out of revenge for the Mickelberg evidence. And the other one, a chap called Lewandowski, who was close to death, volunteered that all the evidence they'd given, he said, I was astonished that it was accepted. All the evidence they'd given was false, including the confessions. He said, I said to Don Hancock when we arrested the Mickelbergs, but Don, we've got nothing on them. Don't worry, said Don, we'll get something soon, it'll get better. And about a month later, Don said, come on, Lewandowski, come into the room here and we'll produce the confessions. Just the two of them, no one else. And Don dictated the question and answer, question, answer, question, answer. It was quite extraordinary. They tried to make the confessions, and did, so that nothing in them could be shown as being incorrect. So it was all very general stuff. The so-called confession of young Peter Mickelberg, he was young, was, question, where did you hide the gold, Peter? I'd love to tell you, Mr. Hancock, but my brothers would kill me. It just sounds so corny, but and so things like that. So false evidence is one, and in Ostick, which was mentioned, in the case of Scott Ostick, I drew up the petition, and I would have taken the matter to trial, but I was made governor, as we mentioned, so I passed that over. But Scott Ostick was convicted on the basis of, again, circumstantial evidence, a planted piece of evidence in a paddock, a knife, which, as it turned out, ultimately was proven not to be, that couldn't have been the murder weapon, but it was planted there because the police thought that it would be en route from the murder place to his own home. So they planted that, and despite the fact that it had been thoroughly searched by some investigators, really skilled investigators before, and a cigarette pack on the table of where Ostick lived, which, lo and behold, had some blood on it, blood stains. The trouble with that evidence, as was later discovered, was that when the police forensic people first went into the Scott Ostick home, and they took film of everything, the cigarette pack wasn't there, but later on it was there, with the blood on it. How did it get there? To this day, no one's prepared to say. So that's one way, false evidence. Bad science, definitely. Chamberlain case is a great example of that. Justice Walling, when he conducted an inquiry, one of several inquiries into the Chamberlain conviction, made a remark to the effect that all of the evidence, the scientific evidence given at the Chamberlain trial, was flawed and unacceptable, all of it, including the evidence given by Professor Cameron from the UK, who gave evidence which was quite damning of the Chamberlains, and was also, for example, saying that he carried experiments and a dingo couldn't possibly have inflicted the marks and so forth. So there's bad evidence, bad science. A very recent example in prominence, of course, is the case of poor Kathleen Folbig, who spent 20 years in prison, essentially on the basis of evidence given by a forensic pathologist, a Dr. Carlar. And Dr. Carlar gave evidence which was to the effect, and it's breathtaking, that Kathleen Folbig, all 4 of her children had died very young and of unexplained causes. And he said, I think he must have been reading the report of Professor Sir Roy Meadow from the UK, He said, 1 unexplained death is a tragedy, 2 unexplained deaths is suspicious, and 3 is murder unless proved otherwise. How do you like that? And it got in. Professor Roy Meadows, in a number of cases, including the sad cases of Sally Clark and Angela Canning in the UK, both wrongfully convicted of the murders of their children, he gave evidence in each one and a number of other cases of cot deaths in which he said exactly that, until ultimately, when it was revealed that that was the evidence he gave, the Royal Statistical Society of the UK came out and said this is utter rubbish. How could he possibly say those things? But he did, and one of those poor ladies spent something like 12 years in jail. When she finally came out, you imagine the stress on that poor lady. She had been convicted, she lost her children for a start, whom she loved, her little infants. She'd then been convicted wrongfully of their murder. She came out and she became an alcoholic. She was just totally a mess. So that can happen. There's a case of Keogh in South Australia. You may have heard of it, Keogh. In Keogh's case, he was convicted of the murder of his fiancée. They cooked up a suggested motive which didn't stand scrutiny, but the main thing was the evidence that was given against him by Dr. Manock. Now, Dr. Manock was the government pathologist, except that he didn't have any degree at all. And he already, when he gave evidence against Keogh, he'd already given false or wrong evidence. I wouldn't say false, he just gave wrong evidence in a number of cases, including one case where he gave evidence at the trial of a mother and father, or 2 people who were charged with the murder of a young child, and he said, no, this wasn't murder, this was running down. It was totally it was murder, all right. So he'd actually got an acquittal. He was instrumental in getting an acquittal of some people who were, in fact, murderers. Keogh spent 20 years in prison on the basis of his evidence. Time after time, experts came along, eminent people, and said, that evidence given by Dr. Manock is totally, totally false. It's wrong. But because in those days, back in those days, you couldn't get he'd exhausted all his rights of appeal, you couldn't get an appeal again, second appeal, unless it was referred to the Court of Appeal by the Attorney General, and the Attorneys General, 2 of them in succession, refused to refer his case back despite the overwhelming evidence that the evidence of Manock was false. And ultimately they passed legislation in South Australia, which we've followed in Western Australia and has been followed also in Victoria and in Tasmania, which bypasses the need to get an Attorney General's reference on a petition to get back to the Court of Appeal, and enables you to go straight to the Court of Appeal to show why the Court of Appeal should look again because of the fresh evidence. And as soon as that happened, despite the fact that all the evidence that was produced to the Court of Appeal had been produced to successive Attorneys General who refused to send it back to the Court of Appeal, when it got to the Court of Appeal, they took about 2.5 months to return the verdict of not guilty. So things can go wrong. Mallard case was mentioned. Well, prosecutorial misconduct leaps to my mind, because Mallard, who incidentally suffered bipolar, he was bipolar, so he thought that when he was telling the police, as he did, his reconstruction of how the murder of this poor woman in Glyde Street's a bad place actually, how it happened, they were taking that as his confession. But it's well known, I'm sure Harlene's nodding, people who suffer from bipolarity often suffer also from grandiosity, and he thought he was helping the police. But the thing that got me involved in it, by that time he'd been about 10 years in jail. I didn't do the trial, and he'd gone to the Court of Appeal and then to the High Court and been successful in reversing the conviction of murder. The thing that got me was when I read the only videotaped record of his so-called confession, he concluded it by saying, you know, this is all my reconstruction. I think that's what I think would have happened. That was taken as a confession. So, when it was referred to me by chance by the British consul, for which I then acted as pro bono counsel, they referred it to me because his parents were of British ancestry and they tried everything. So anyway, I read it and said, "This is terrible. We've got to get some fresh evidence." And the fresh evidence we got was this: at the trial, the counsel for the prosecution, who had all the file, said to ladies and gentlemen of the jury, "Here is a drawing that Andrew has made of the murder weapon." And he had drawn as part of his helping out the police. And they said, what was the murder weapon? He said, "It would have been a wrench." "Draw us the wrench." He drew it. He says, "Thank you. So that's what the murder weapon would have been?" He said, "Yes." And sometimes he lapsed into first person. But yes, that's what the murder weapon would have been, because she was a jeweller and she would have had a wrench. So the prosecution produced that at the trial and said, Jamie Edelman and I counted, I think it was 23 times he used the term, the murder weapon was the wrench, and he's drawn it. Trouble with that is that there had been an experiment carried out by the police and a forensic pathologist, Dr. Cook here in Perth, to see whether any wrench could possibly have inflicted the wounds that were on this poor murdered lady's head. And the conclusion was no, couldn't have. So why didn't the jury get that evidence? It was overlooked. Overlooked. It was there sitting with a letter from the detective sergeant in charge of the investigation, who said, "Some of our detectives aren't really that sure that this was a confession, and we've had this experiment with the wrench, and it looks as though it's probably not a wrench at all," and yet the prosecution went ahead and put it as being a murder weapon, which it wasn't, which he has drawn, and they couldn't find the murder weapon. In fact, all the time, certainly when we got the appeal going, we subpoenaed a lot of stuff from the police, and one of the things we asked for was all fingerprints taken from the murder scene, none of which were Andrew Mallard's, of course, because he'd been nowhere near it. They did have a palm print they'd found, which they couldn't identify. The palm print was the palm print of a man who'd already been arrested, found guilty of murder, using exactly the same modus operandi as on this poor woman that Mallard was supposed to have murdered. So prosecutorial misconduct, I think, is a fair description. And then there is incompetent counsel. I mentioned the case of Rinaldi. When I ceased to be governor and came back, a lady got in touch with me and said my husband's been wrongfully convicted of a sexual offence. I looked at it, I said, well, the judge's direction was all right, but I can't find in the transcript you sent me any evidence of your husband. She says, that's because his counsel said you shouldn't give evidence. And I said, didn't he want to? He said, yes, he was ready to go, but he didn't give evidence. Anyway, we won that appeal. We won that appeal, Jeffrey, back in 2000 and, when was it? 2018, so it's fairly recent. I think that was a landmark decision because it's sworn counsel. They can't just bowl ahead without properly explaining to their client what they're doing. Well, what's the conclusion of that? I think, first of all, there is a need for expert evidence given at trials to be subject to peer review. That's an absolute necessity because too often, either wittingly or not, experts continually briefed to give expert evidence by the prosecution start to side with the prosecution. That's a fact of life and very hard to break them down. We need a peer review. The second thing, and I've urged this for must be 25 years now, we should have here in Western Australia a criminal cases review commission. And I say that for the reason that the cases in which I've been involved where wrongful convictions have been set aside were cases where there was a lot of outside help given to the person who was shown to have been wrongfully convicted. In the Mickelberg case, they had their parents, they had a lot of friends, they had an ex-helicopter pilot who was on their side, all kind of group of people, brilliant and devoted to the cause and helping in every way they could. In Mallard's case, he had his parents and sister who just pushed and pushed and pushed. They wouldn't give up, and finally they got through. I suspect there are a lot of people who have gone to jail innocent and have had no recourse to any assistance whatever. A criminal case review commission would enable a person who says that he or she's been wrongfully convicted to make an application to the commission, explain why it's been, and the commission then has, in the UK, extraordinary powers to subpoena information, get information, and ultimately, if they conclude that there's a strong case, refer it to the Court of Appeal. So there are the things that are needed. I'm looking forward, Harlene, to your speech on Peter Ellis. It's an intriguing case. It's a bit like some of the other cases I mentioned where there's been a posthumous clearing of the person wrongfully convicted. So congratulations for what you've done, Mark. Thank you.
Thank you so much, Malcolm, for sharing your expertise and your depth of knowledge in relation to this. And I'll just mention that the Fremantle prison at the moment has some artwork displaying some wrongfully convicted people in Western Australia, and it does beg the question as to why it is that we have so many wrongful convictions in this state, going back to Daryl Beamish, John Button, the Mickelbergs has been mentioned, Andrew Mallard also has been mentioned, but of course WA is not the only place that experiences these issues. We of course have Chamberlain, which has been mentioned, Keogh in South Australia, and more recently of course Kathleen Folbig, who was convicted, well, spent 20 years in prison. And I think that's perhaps led to a little bit of a political agenda around a criminal cases review commission or equivalent, both in this state, well, across the country essentially. So I think it'll be interesting to keep an eye on all of that. So Professor Harlene Hayne CNZM will be no stranger to many in the room. She has of course been the Vice-Chancellor of Curtin University since April 21. She was previously the Vice-Chancellor of the University of Otago in New Zealand, and I have a special affiliation with Dunedin because my father was born in Dunedin. But one of the things I'll say about Harlene is that she's a Vice-Chancellor that stays very connected with research. And that's not something that can be said about all Vice-Chancellors, and so really appreciates, I think, the academic game that many of us play, which I think is so important in your role. So thank you for keeping that connection, Harlene. Of course, very well placed to talk about this subject, given your expertise in the area of memory development and adolescent risk-taking. And so I know that everyone here is going to be very interested in what you have to say, so welcome and thank you.
Thank you very much, Robert, for that very warm introduction, and thank you, Malcolm, for your introductory comments as you were speaking about all the different ways that a wrongful conviction can take place. I think almost every single one of those characterizes the case that I'm going to describe today. So not one thing went wrong, but just about everything that could go wrong did. I'd just like to start by acknowledging that we are having our meeting today on the traditional lands of the Whadjuk people. And as a newcomer to Australia, every day I feel blessed to live on the lands of the oldest continuing culture anywhere in the world. And like Professor Cunningham, I support their very gentle call for a voice enshrined in the Australian Constitution. And for those of you who have access to the Vice-Chancellor's note to staff, I think tomorrow we will be including a link to a fantastic set of FAQs developed by Hannah McGlade, who is a member of the Faculty of Law here, that will help for anyone who's mystified by what's going on. She's done a very good job, I think, of busting a few myths and explaining the big decision that is before the country by the end of the year. I need to start today with a bit of a disclaimer. I am not a lawyer by training. I am actually a psychologist. My primary area of expertise is memory and memory development. So I am not speaking to you today as a legal expert. What I would like to do instead, however, is to walk you through a case that I've had the privilege to work on over more than 20 years. That was a wrongful conviction and, as Malcolm has intimated, was recently overturned by the New Zealand Supreme Court. And in giving my description today, I want to give you a bit of a history of how we got where we are today, and in particular, walk you through the way in which I, as a mere psychologist, got involved in this case and the way in which I had the opportunity to contribute over many decades. So, here is the person in question. Peter Ellis was a worker, a childcare worker in an early childhood center in Christchurch, and he had been working at the Christchurch Civic Childcare Center for several years. The initial allegation against Mr. Ellis was made by a child who was currently at the center, who came home after school one day and said to his mother, "I do not like Peter's black penis." And that child's statement, or his mother's recollection of that statement, led to a flurry of activity over many, many years. And 118 children were eventually interviewed in the Ellis case as part of the original depositions. He was arrested on his 34th birthday, and the jury trial commenced in April of 1993. It lasted 6 weeks, and in the end, although 113 children were interviewed, 13 child complainants provided testimony against Mr. Ellis during his trial in the High Court. He was charged with a total of 28 sexual offenses against these 13 children, and all of the children had previously attended the Christchurch Child Care Center. The charges included a range of things like indecent assault, male inducing an indecent act with a girl, indecent act upon a boy, indecent act upon a girl, attempted sexual intercourse, and sexual violation. Now, the Crown's case was based primarily on the evidence of these 13 children, and it was admitted into evidence through pre-recorded evidential interviews that took place prior to the trial itself. Now, there are a number of things about this case that make it incredibly complicated. One of those was the age of the child complainants themselves. They ranged in age from 2 to 5 years at the time of the alleged incidents. They were between 5.5 and 9 years old at the time of their evidential interviews, and they were between 6.5 and 10 years old at the time of the High Court trial. And the ages of these children and the delay over which they were interviewed is something that I will return to later. Now, during the course of their testimony, the complainants made allegations about Mr. Ellis, not all of which resulted in charges against him or in convictions against him as a result of the trial. The complainants alleged that Mr. Ellis urinated on the children, that he had forced children to drink his urine and eat his feces. They alleged that he had inserted needles and sticks into their bottoms. The complainants alleged that many of the events that took place outside of the child care center, involved things like tunnels, cages, ladders, chimneys, trapdoors, and other people, including other workers at the child care center, Mr. Ellis's own mother, and a number of other unidentified male and female adults. On June 5th of 1993, the jury found Mr. Ellis guilty of 16 counts against 7 children who provided evidence against him, and he was sentenced to 10 years in prison. During his time in prison, there were 2 unsuccessful appeals. Both of them were unsuccessful. One was on reference from the Governor General. Mr. Ellis completed his full sentence in the year 2000, and after he was released on March 10th of 2000, a ministerial inquiry was established by the then Minister of Justice, the Honourable Phil Goff. And the terms of reference of this inquiry were to investigate the reliability of the children's evidence that were given by the complainants in Mr. Ellis's case, and to report on whether or not there were any concerns about the way in which the evidence was elicited that would render the convictions unsafe. And Sir Thomas Eichelbaum, who was a former Chief Justice of the New Zealand Court, led that particular inquiry, and it was released in 2001. Now, Sir Thomas's opinion was very interesting, and he concluded a number of things. There were two experts who provided additional support to Sir Thomas, Professor Graham Davies and Dr. Louise Sass, and they led to two conclusions. One, Eichelbaum concluded that, in fact, the standard of the interviews that were conducted with the child complainants were representative of best practice at the time. And the second conclusion that Eichelbaum reached was that the standards of the interviews was substantially better than those in another quite notorious case in the United States, the Kelly-Michaels case, which I'll explain to you in a little bit. But the Kelly-Michaels case has become sort of the poster child in the wrongful conviction arena with child victims because there were a number of very serious problems in the way in which those children were interviewed. But it was Sir Thomas's view that the evidential interviews in the Ellis case were substantially better than those in the Michaels case. At about the time that the Eichelbaum, after Peter had been released from prison and the Eichelbaum report was released, I was actually hosting a very influential psychologist from the United States at the University of Otago, a woman by the name of Professor Elizabeth Loftus. She is probably the best known world expert on memory in the courtroom, and she was coming to the University of Otago to give a talk in an Eminent Speaker Series very much like this one. Mr. Ellis read in the newspaper that Professor Loftus was coming to visit me and speak at my university, and he contacted me and asked whether or not it would be possible for me to arrange a meeting between him and Professor Loftus while she was in New Zealand. And I said I was very happy to do that. So Mr. Ellis traveled from Christchurch to Dunedin, where Professor Loftus was speaking, and I made the arrangements for the two of them to meet in a relatively off-the-grid location, given the prominence of Mr. Ellis at the time. So I brought the two of them together. It was the one and only time I'd ever met Mr. Ellis, and I have never spoken to him since that day. And as I got the two of them settled, I was getting ready to leave, and Elizabeth said to me, like, "Where are you going?" And I said, "Well, you know, I do research with children, and the man is a convicted pedophile. Like, this is not going to be a good look for me to be sitting in a room with him." And I am forever grateful for her gentle patience with me, because she just put her hand on my arm and she said to me, "Yeah, I can see how that would make you a little bit nervous. But what if he isn't guilty? And what if you could do something about it?" So that was a big smack for me, and it sort of put me in my place right away. And really what she was reminding me was the huge obligation that comes with privilege. And it is something that I have not forgotten from that day. I have had an incredibly blessed career. I've had the opportunity to work with dozens and dozens of brilliant students and to investigate things that are really important. But that privilege really does come with it, bring with it a huge sense of obligation to do something with the knowledge that we have obtained. And the other thing that she reminded me of was the incredible gift that we all have of academic freedom. That if anyone has the opportunity to go out on a limb and do something for someone else, it's academics. In New Zealand, the gift of academic freedom is actually enshrined in our legislation. And here in Australia, we are working very hard to make sure that that is the case as well. So that's how I got involved. I was really shamed into trying to think of ways in which I might be able to bring my knowledge and expertise to bear to potentially help someone who needed my help. But the real question was, what could I do? You know, being indignant isn't really a good defense for someone who's wrongfully convicted. You actually have to come up with the goods to figure out what went wrong in this particular case and how we might be able to make it right. So I started to look at this case as a scientist, and really, when my students and I started talking about it, what we realized is that Sir Thomas Eichelbaum's opinion could really be converted quite easily into a number of testable hypotheses. So, for example, hypothesis 1, the interviews were consistent with best practice. That's actually a testable hypothesis. And the second one was that the interviews were actually better than those that were conducted in the Kelly-Michaels case, which is a case that is very well known for its appalling interviewing. So really, what we set about to do was to determine whether or not we could empirically test these two hypotheses using data that was at hand. So the question is, how did we do it? Before I tell you what we did, I need to just give you a bit of background for those of you who are unfamiliar with the Kelly-Michaels case. There are very many similarities between this case and the Ellis case. Kelly-Michaels was, again, working in an early childhood center in New Jersey in the United States. She was 26 years old at the time of her involvement in this case. The initial allegation, once again, came from a 4-year-old boy in her classroom. In this case with Kelly-Michaels, the mother was taking the boy's temperature rectally at home, and the boy made a comment that this is how Miss Michaels, this is what she does to me at school. And it was that allegation by that child that again launched a fury and an investigation about her behavior in her classroom. There was no physical evidence to support any of the allegations in the Michaels case. The child witnesses, again, were very young, 3 to 5 years old. Kelly-Michaels was, again, rendered guilty by a jury of her peers, and she was sentenced to 47 years in prison. She actually served 5 years of that sentence, but the appeals court actually reversed her conviction, and the prosecution, I think quite wisely, made the decision not to retry her case. All of the charges against Kelly-Michaels were dropped on December 2nd, 1994. So the historical time frame here is very similar to the time frame around the Ellis case. Remember, this is the case that Sir Thomas said that the Ellis interviews were substantially better than those in this particular case. All right, so I had, at the time, a fantastic stable of students in my laboratory, all of whom were psychology students, but also some of them were law students as well. So many of my students ended up doing double degrees between psychology and law, and a lot of our work really sat at the nexus of forensic psychology. So what we did was to conduct an empirical analysis of these two sets of transcripts, those transcripts of the evidential interviews in the Ellis case and the transcripts of the evidential interviews in the Michaels case. We coded every single question in every interview of both of those cases. 2 independent observers coded approximately 1/3 of the interviews, and the coding scheme is actually quite simple. I could teach everyone in this room to do it in about 5 minutes. The reliability was very high, so the relationship between the 2 coders was between 96 and 99%. Now, the coding scheme that we used was actually based on our prior research in children's memory. So we had been interviewing children and coding both the nature of our interviews and the nature of children's answers for well over a decade. And we essentially used that empirically based coding scheme to code the interviews in these 2 cases. So we coded questions. Each question was assigned to 1 of 5 categories. 2 of those categories involve what we consider to be best practice questions. And there's really very little disagreement amongst professionals right now about the nature of these best practice questions. The gold standard interview question for a child is the free recall question. And essentially it is, can you please tell me everything you know about X? And that free recall question gives the child virtually no information from the interviewer, and we are requesting the child to provide information in response to that question. Children's accuracy, even very young children's accuracy in response to free recall questions, all other things being equal, tends to be extraordinarily high even when they're interviewed after very long delays. The other good category of questions are direct open questions like what happened in the playroom. So this is a slightly more specific question that you would use to follow on once the child had mentioned the playroom. But again, the additional information that the child is going to provide has to come from them, not from the interviewer themselves. And again, children's response to these questions is their accuracy is very high. But obviously, not all interviewers stick to the script, and they often ask other questions that are associated with much lower levels of accuracy. So one might be direct close questions, and these are yes-no questions. And an example of that would be, was anyone with you when that happened? And again, children's accuracy with respect to direct close questions is not very good. It's obviously not very good when they're asked suggestive questions like, the other kids told me that X happened, did it, which is a very flagrant suggestive question. And again, children are very likely to endorse these kinds of suggestions even if they didn't happen, the event didn't happen to them. And the other kind of question that is discouraged are choice questions. Did it happen in the classroom or did it happen in the playroom? So we looked at both sets of transcripts. We coded every question into one of these categories. And the question is, what proportion of the questions were in the good category and what proportion of questions were in the bad category, and was there any difference between the two cases? So here's one piece of empirical data from that analysis of the children's transcripts, and I'll just walk you through this because there's a slide that follows the same format. So the dependent variable here is the number of questions per interview that the children were asked that fell into the category of free recall, direct open, direct close, suggestive, or choice. And the Ellis questions are indicated in the solid bars, and the Michaels case are indicated in the gray bars. Now, there are a number of things that you should hopefully be able to discern from looking at these data. The first, obviously, is that there were virtually no free recall questions in either case. In fact, it turns out that there were no free recall questions in the Kelly-Michaels case, and one child in the Ellis case was asked one free recall question during the course of their interviews. With respect to direct open questions, the Ellis interviewers were much more likely to ask those kinds of good questions, so there were many more direct open questions in Ellis than there were in Michaels. If we look at the other side of the figure, however, and start to consider the questions that are more compromising, the ones that are associated with lower levels of accuracy by children in experimental studies, there was absolutely no difference in the number of direct closed questions in the two cases. Children in the Ellis case, however, were asked more suggestive questions per interview and were asked more choice questions per interview than children in the Michaels case. Now, as we started to think about this, we thought, okay, well, we looked at every single question from basically the time that the interviewer asked the first question about, can you tell me about X, or why are you here, to the very end of the interview. And to take a slightly more conservative approach, we thought maybe it would be better to actually count the questions up to the point of an allegation. Because quite frankly, what happens after an allegation isn't really that important. So if the interviewers did really a good job up to the point that they got the information that was used in a charge against Ellis, that would be fine. If all the bad questions happened at the tail end of the interview, probably not very good professionally, but it may not have compromised Mr. Ellis's chances for justice. So the next slide shows you the number of compromising questions. So that's essentially the sum total of all of the questions on the right-hand side of that figure. Now remember, these were per interview, and many of the children had multiple interviews. So this is the total number of questions across interviews prior to an allegation. And what you can see here very clearly is that children in the Ellis case were asked over 300 compromising questions prior to an allegation. And the Michaels children were asked, obviously still too many, 150, but in the Ellis case, they were asked twice as many compromising questions before they made an allegation than they were in Michaels. All right, so if we just look at what the data that we've examined so far, there were almost no free recall questions in either case. There were more direct open questions in Ellis than there were in Michaels. But there were no differences in direct closed questions, and in fact, there were more suggestive questions in Ellis than there were in Michaels, and there were more compromising questions prior to each allegation in Ellis than there were in Michaels. So if we return back to the original hypotheses that generated all of this activity, with respect to Sir Thomas's conclusions, the interviews were consistent with best practice. The answer to that is quite clearly no. In terms of free recall questions, they were virtually non-existent in either case, but in particular in the Ellis case. And the second thing is that Sir Thomas concluded that the interviews were better in the Ellis case than they were in the Michaels case. But once again, the answer to that is clearly no. I'm sorry, but Sir Thomas Eichelbaum and his experts were uncategorically incorrect when it came to their conclusions regarding this particular case. All right, so this is where we stood, my students and I, again, indignant, enraged, sitting in my office in the psychology department at the University of Otago, thinking, what a terrible injustice has happened, what are we going to do? Well, the next step was the formation of the New Zealand Innocence Project. And the New Zealand Innocence Project was founded in May of 2007. And it was a joint venture between the psychology departments at Victoria University of Wellington and the University of Otago. So my colleague, Professor Marianne Gary, who was a professor in the psychology department at Victoria University of Wellington, and I got together and established the Innocence Project New Zealand as a psychological event. You know, why psychology? If you look across innocence projects around the world, they initially started in schools of journalism, and then they morphed into law schools. But at the time that the New Zealand Innocence Project was founded, it was the very first to actually be housed in schools of psychology. And so as a group full of lawyers, you might ask yourselves, well, why in the world would you put your Innocence Project in a school of psychology? But the reason for this is, I think, threefold. 70% of the wrongful convictions around the world are actually due to eyewitness misidentification, which is clearly a memory problem, which is well and truly within the domain of psychology. Allegations of child sexual abuse, oftentimes, or almost always, there is very little physical evidence or any other witness to corroborate the child's allegations, and so the court must rely exclusively on the child's report, which is based on their memory of that particular event. And obviously in cases of historic allegations of abuse, when people are bringing claims against others over long periods of time, even if there would have been physical evidence at the time the event occurred, most of that evidence has disappeared. And once again, the court is forced into the predicament of weighing the memory of one person versus the memory of others. So after the establishment of the New Zealand Innocence Project, we hosted our very first conference in December of 2007, and that was the first opportunity that I had to present our data regarding the Eichelbaum conclusions. Now, there were journalists at the conference, as you might imagine, and our findings were very widely reported throughout New Zealand at the time, and drew a huge amount of attention from many of the lawyers who had worked on the case at various points in time, but also drew a huge amount of interest from the general public. So this is how I essentially got myself involved in this particular case. So Mr. Ellis's legal representation was quite extensive. Rob Harrison led the original, he defended Mr. Ellis in the original High Court case. Graham Pankhurst QC, now I guess KC, led the Court of Appeal matter in 1994, and then Judith Ablett-Kerr led the matter in 1999. And at the time of the Innocence Project conference, Judith Ablett-Kerr was preparing a case to go to the Privy Council in the UK. So it was prior to the establishment of the Supreme Court in New Zealand, and it was still an opportunity for people to take their case to the Privy Council at that particular point in time. Judith Ablett-Kerr got in touch with me after my presentation, and we had several meetings. We had the opportunity to look through my data, and from her perspective, it was the kind of fresh evidence that is actually required by the court in order to have another go in the courtroom. My original instructions were provided by Mrs. Ablett-Kerr, and once I was instructed by her, I then had access not only to the evidential interviews, but I also had access to all of the court transcripts and the transcripts of the depositions, as well as to the boxes and boxes and boxes of evidence that had accumulated in this particular case over more than a decade. So, I worked with Judith Ablett-Kerr for a while. To be quite frank, I think the cost, emotional, not necessarily financial, the emotional cost of this case on anyone who has ever been involved in it has been massive. And people became very risk averse about taking the case one more time, particularly when everybody who was this was it. It was either you were going to go to the Privy Council or eventually to the Supreme Court, but whatever happened next was going to be the last-ditch effort. And so Mrs. Ablett-Kerr was understandably cautious, and I worked with her for probably 3 or 4 years on developing my brief of evidence in this particular case. I suspect that most experts have never spent this much time developing a brief, but mine was Class A because we just wanted to make sure we had everything in place before we moved any further. Peter was getting frustrated at this point, and so he moved his counsel to a man by the name of Kerry Cook, and Kerry decided that rather than going to the Privy Council at this point, he thought it would be best if the case were heard in New Zealand at the Supreme Court, and so I started then working with Kerry Cook on developing the case for the Supreme Court. Again, several years went by, and eventually Peter went back to his old friend Rob Harrison, who was the man who had defended him in the original High Court trial, and the ultimate team of lawyers that represented Mr. Ellis in the Supreme Court included Rob Harrison, Susan Gray, Bridget Irvine, who was very interesting. She was both a PhD in psychology and an LLB. Dr. Irvine's very first appearance in a courtroom was in this Supreme Court appeal. So any of you who are budding lawyers, hearing her story is pretty darn amazing, but I think she added, bringing her on board was so important for us because she could speak both languages. She could speak both the language of psychology and psychological science, and she could speak the language of the court. And Kingi Snellgar was also a member of that team. The hearing was finally scheduled for November 2019. Unfortunately, Mr. Ellis died of advanced bladder cancer on September 4th of 2019. Now, when this happened, there had never been a case of posthumous continuance of a Supreme Court appeal. So we had to go back to court and argue to the Supreme Court that it was very important for them to continue to hear the case. On September 1st of 2020, the court granted the leave for the appeal to continue. The appeal hearing in the Supreme Court began on October 4th of 2021, and the Supreme Court also made the very brave decision that new evidence would be heard in the court, that they would not actually work exclusively on the papers alone. I was in Australia by 2021, locked down here in Western Australia. So I provided all of my expert testimony over a period of 5 days in the Supreme Court from the comfort of my office in my apartment in Burswood. Peter's lawyers were really sad about that. They thought that it would be better if I were actually in the court, but for my own emotional safety, I think it was better given how involved I had been in this case over so many years. I really did feel like this was the best place for me to be. And all of the experts who testified in the trial did so on screen, and there were experts from all over the world. The US, Canada, and New Zealand testified in the case. All right, so the Supreme Court grounds of appeal, there were 7. One of the grounds was that there was contamination of the children's evidence prior to their evidential interviews, and I'll explain to you how that was defined and how we assessed it as we went forward. That there was poor evidential interviewing of the children, not only the questions that they were asked, but also the use of a wide variety of other ancillary techniques like anatomically detailed dolls, props, etc. Another ground was that, given the complexity of this case and the number of very complex memory factors that were involved, there was absolutely no way that a jury could be expected to understand how different events might have influenced the veracity of the children's reports. So it was very clear that expert evidence from memory experts should have been provided to help the jury in making its way through this very complex case. 2 experts did testify in the original High Court trial. Both of them were psychiatrists. Neither of them were experts in memory. Both experts provided testimony that was incomplete or quite frankly, incorrect. And I'll talk to you about that in a minute. Another ground of appeal was 23G. Section 23G of the Evidence Amendment Act in New Zealand permits an expert witness to give evidence in cases of alleged sexual abuse of children, and the evidence is typically about behaviors that may or may not be consistent with sexual abuse. The rules regarding the original 23G were incredibly convoluted and complex, and there's been a lot of legal discussion about 23G. But what's really clear is that the expert was not allowed to use his or her testimony as a definitive decision regarding whether or not a child had been abused, and they were required to provide alternative explanations for the same behavior. And I'll tell you briefly about how those grounds might have been overstepped. Another ground was the sanitation of charges. The Crown did not charge Mr. Ellis with offenses for which there could have been corroborating evidence. So, for example, one child alleged that Mr. Ellis had inserted burning paper in his bottom. Mr. Ellis was not charged with that offense, but he was charged with other offenses against that same child. Another ground of appeal was that the jury did not see the full set of evidential interviews. In the Ellis case, children were interviewed multiple times over a very long period. In many of the interviews that were not played to the jury, the complainants made allegations that were, quite frankly, fantastical. By way of one example, one child alleged that Mr. Ellis had taken a group of children to the Christchurch City Council and had sexually assaulted them in the middle of a room where the city councillors were all working at their desks. Another child alleged that he had been sodomized not only by Mr. Ellis, but also by friends of Mr. Ellis more than 40 times. This same child reported that he'd been taken to the hospital where Mr. Ellis had put needles in his hand. Now, the jury never heard either bits of this testimony on behalf of the children. And the argument was that had a jury actually been able to hear the child's full story, it might have cast some doubt on other claims that they had made. And the last ground of appeal was the medical evidence that was provided at the time of the trial was incorrect. Now, I am not a lawyer. I'm a psychologist who is an expert in memory, so today I'm going to just briefly tell you a little bit about the kinds of memory evidence that I contributed to the court with respect to those first three grounds of appeal. Now, in my brief to the court, the first thing that I had to do was to outline the current state of play in terms of what we know about children's memory. Now, in cases of suspected sexual abuse against children, we often have virtually no physical evidence or eyewitnesses who can corroborate an allegation or provide a defense for the defendant. So for this reason, in cases of alleged sexual abuse, it is paramount that the child's testimony is elicited in such a way that we maximize their accuracy. We have to make sure that the child's account is both complete as well as accurate. Now, irrespective of whether a witness in court is a child or an adult, their testimony is typically based on their memory for an event in question. So as a memory expert, when we think about remembering, we often think about it in terms of a three-step process. All right? The first thing that happens is that we experience something, so we encode that information that has happened to us. And if it's significantly important, we store it in memory for use at some other point in time. When we are asked questions or we encounter a set of circumstances for which that information might be useful, it is retrieved, and then we can talk about it or think about it or reflect on that information in some way. Now, what's really important about this is that memory does not work like a tape recorder, all right? It is a reconstructive process. And every time we have the opportunity to retrieve a particular memory, things that happen to us at the time that memory is retrieved also get encoded as part of that representation, all right? So new experiences that happen at the time of retrieval get encoded back into the representation and then become stored in memory. So if you think about your own autobiographical memories, for all of us, those memories are a compilation of direct experience that we've actually had, and then all of the other bits and pieces of information that we have collected up along the way, all right? Every time we think about, retrieve, or reflect on that memory, stuff that's happened at around that time gets added as part of that memory representation. Now, under most circumstances, this process works pretty well, all right? And it serves us really well because it actually allows us to combine information that happens temporally separated in time into useful knowledge that we can use in the future when we encounter similar kinds of circumstances. Over the course of human evolution, there's absolutely no doubt that our brains were selected to be information gatherers, all right? It was really important for our survival to figure out where we could find food and where we could find shelter. It was less important to actually monitor the source of that information. So it didn't matter whether or not you found a good place to sleep because you stumbled across it yourself, or whether your mate drug you by the arm and told you that this is a warm cave and you should probably get into it. So our brains have really not been selected to source monitor where we get information. And in fact, that's been selected against. Now, as memory researchers, we often talk about suggestibility as if it were some kind of special memory process, but it really isn't. It actually just simply describes the way in which our brains have evolved to gather information from any source that is available to us. And once that information becomes part of our story, it's sometimes incredibly difficult for us to differentiate between things that we've actively experienced and things that we have only been told about. And for children, this barrier between what happened to me and what I've heard about is actually particularly leaky. So research on children's memory has clearly shown over many decades that children will incorporate things they've been told into their memory in their subsequent retelling or original telling of a particular experience. And I think the more important thing that we have learned over decades of research is that once children accept the kernel of a particular story, they will also elaborate with details of their own, providing quite well-developed stories about completely and utterly fictitious events. So the point here is that when it comes to memory, we do not have a completely accurate representation of the things that happen to us. And so every time we have to rely on memory in the courtroom, we need to think very carefully about the ways in which a particular witness's memory might have been altered by either the way in which they were questioned or experiences they had prior to that interview. So from a forensic standpoint, interview questions become incredibly important, but equally and in fact more important when it comes to children, exposure to additional sources of information that might contaminate their accounts is something that we need to be very careful about. Now, in the case of Mr. Ellis, there were multiple sources of contamination, and in fact, this is one of the things that all of the experts who have reviewed this case would agree on, but it is probably one of the most well-documented cases of child sexual abuse and also one in which the opportunity for contamination has been the greatest. As we were reviewing all of the materials, including not only the evidential interviews, but also the transcripts of the matter in the court, as well as depositions that occurred prior to the High Court hearing, we identified a large series of potentially contaminating factors. There was a group of things that we've kind of referred to as general chatter around the time. The first meeting of the creche parents occurred on the 2nd of December in 1991, and Ms. Sue Sidey, who actually ended up being the primary evidential interviewer in this case, attended that meeting and she spoke to the parents. The parents were actually informed that the police were concerned about alleged incidents of sexual abuse, and they were told to be alert to any behavioral changes in their children. They were explained what the evidential interview process would be like, and the meeting briefed the parents generally about the allegations that had been made against Mr. Ellis. Following that, in March of 1992, there was a Knox Hall meeting, and many of the creche parents attended that meeting. Dr. Karen Zealis, who will become a very important player in this case, attended that meeting. She was the expert witness psychiatrist for the prosecution during the original High Court trial. She was present at the meeting, as was Dr. Colin Eade, who was leading the investigation, and Ms. Sue Sidey, who was the primary evidential interviewer, also attended the meeting. A handout was prepared by the police for the parents who attended the Knox Hall meeting, which listed a number of behavioral changes that they should be looking for in their children. The parents were told that it was okay to question their children, but not to use suggestive questions. And once again, during the meeting, the parents were again briefed on the kind of allegations that had been made against Mr. Ellis, and they were provided the opportunity to interact with each other. And last but not least was the informal support group. This group met beginning on July 1st, 1992, and it met every 2 weeks until the trial. At one meeting early of the informal support group, which was attended by many of the creche parents, the mother whose child made the original allegation, but for whom he never actually made an allegation in response to an evidential interview, she took it upon herself to become the sort of group support worker, and she compiled a list of all of the different allegations that the children were making against Mr. Ellis, and she shared the list with the group, and then the group was augmented and added to on a regular basis. So the list became a kind of a physical representation of all of the different things that the children were alleging. And parents had access to that and the opportunity to question their children about whether or not this had happened to them. There were also extensive parent-child conversations during this period of time. Many parents under oath admitted to having quite detailed discussions with their children, and in fact, most of them admitted that they overstepped the line with respect to the kinds of questions that they asked their children. Obviously, this kind of constant parental interviewing provided a fantastic opportunity for the children's memories to be contaminated prior to the evidential interviews, and it also provided a very efficient way for information that was being reported by one child to be shared with another. Now, most of the time, we just have to speculate about what happened during these conversations, although all of the parents testified in court and many of them did admit to stepping over the line. But one parent quite helpfully recorded her interview with her own child, and we actually got access to that recorded interview. She brought it to the police as evidence, and so that was part of the box of things that I was gifted by Mrs. Ablett-Kerr. My students and I coded that interview in the same way we had coded the original evidential interviews with the Ellis children, and during that interview, the mother asked 221 abuse-related suggestive questions of her daughter. There was also an error of accusation, obviously, going around at the time. Most of the parents made it very clear to their children that Mr. Ellis was in trouble, and many of them indicated that he was in prison, thus establishing an error of accusation. And obviously, one of the things that we know on the basis of empirical research on children's memory is that children are much more likely to make false reports about an individual if they're provided with this kind of information prior to an interview. So if a child is told that Robert Cunningham is a bad person, before we ask questions about Robert Cunningham, they are much more likely to make false allegations against him. There was also multiple opportunities for sharing. Many of the complainants' parents had ongoing contact with each other, as I indicated, and there was obviously this list that was going around where parents were augmenting and sharing information amongst themselves. And there was also the opportunity for many of the children to speak amongst themselves. So a subgroup of the original complainants were also part of the same friend group, and during the high court trial, many of the children testified that they had had multiple conversations with their friends and described the nature of those conversations. There was also multiple opportunities for children to overhear conversations both between their parents, other people's parents, and professionals who were involved in the case. And again, there's a very large extant literature on particularly young children's ability to overhear a conversation and sort of take it and run with it, developing quite elaborate accounts of things that haven't happened. One mother actually, when discussing the allegations that her child was making, asked her child to demonstrate what had happened when she was naked with the child in the bath, and reported under oath, described quite clearly what had happened during that bath scene, both what she had asked her child to do and the response of her child. And that same mother also, in order to help prepare her child for the evidential interview, prepared a booklet with her child that was comprised of drawings that were constructed both by the mother and by the child, and included a narrative that was, again, some of it was provided by the mother and some of it was provided by the child. some children were taken to the location where the alleged abuse was supposed to have taken place. So as the list was going around, a number of addresses started to emerge, and so some of the parents took it upon themselves to drive their children to these locations, including the Cranmer Center, which was the site of the City Council event, but also to other things like the Masonic Lodge and to various addresses where people had said that the abuse had taken place, 404 Hereford Street and 348 Armand Street in Christchurch. And obviously these experiences provided a great opportunity for children to encode the details of these locations, even if they had never been at them before. And many of them described in quite a bit of detail these locations, but if we trace back, it's because the parents had taken them to them just weeks before their evidential interview. And last but not least, there was a series of other sources of information that children had access to. Some of the children were currently undergoing therapy prior to and during their evidential interviews. There was also significant evidence that the children were being read a number of sex education books, and at least one child was taking part in a safe education program. Now, on the surface, none of these things are dastardly, but the key is that these children were being exposed to a huge amount of sexual content that had the potential to give them some promiscuous knowledge about adult sexual behavior. All right, so, sorry. Those were the 14 potentials, almost like a gunshot. That'll wake you up. So those were the 14 potential sources of contamination that my students and I identified in the course of each of the 7 complainants for whom Mr. Ellis was convicted of at least one count. Now, we reviewed the depositions and the trial transcripts to identify the existence of each source of contamination for each child. Now, that doesn't say that this event caused contamination. All we did was to simply identify whether or not a particular child had been exposed to one or more of these 14 sources of contamination. We also reviewed, once again, the transcripts of all the evidential interviews, and in addition to looking at the questions, we also identified a number of other ancillary interview techniques that are associated with a decrease in children's accuracy, and that includes the use of free drawing, dolls, toys, and reference to other people's statements. And so we pulled all of that out of the evidential interviews. And for each child, as part of the development of the brief that went to the Supreme Court, we constructed a timeline to illustrate how and when each child was exposed to potential sources of contamination or to inappropriate interview techniques. And I want to share with you some of the timelines that we developed. Now, I apologize for the size of this, and it is a little bit complex, but I'm going to walk you through it. And once you get this one, all of the rest, it will become a gestalt, because they all look pretty much the same. Now, the first thing to orient yourself to is the line, which represents time. And on the left-hand side, we have the child's 5th birthday. And that's important because in New Zealand, every child goes to school on their 5th birthday, all right? Not the semester after their 5th birthday. On the day you turn 5, you're sent to school. And so we know for a fact that these children had left the creche at the time of their 5th birthday. And at the far right-hand side, that little symbol represents the High Court trial. So that shows you it depicts time between the child's end of time at the creche and the High Court trial. Now the blue boxes, the big blue boxes, which these represent the evidential interviews and when they took place. The green circles represent whether or not that evidential interview resulted in a charge against Mr. Ellis. And all of the other symbols refer to exposure to potential sources of contamination or to issues that we identified with the evidential interviews. Okay, so with respect to this child, there are a number of things that I think you should take note of. The first thing is that this child's first evidential interview took place almost 4 years after that child had left the creche. All right? So she was interviewed. The experiences that she was being questioned about occurred a very, very long time ago in her young life. Prior to her first evidential interview, her mother attended the Knox Hall meeting, had several conversations with her child, read her child a range of sex education books, and spoke repeatedly to many of the parents. Now, the first evidential interview with this child, no disclosure was made, and the interview was not played to the court. The second evidential interview occurred 2 days later, and during that interview, the interviewer did not go over the ground rules for the child. For example, she did not necessarily go through the statement about truth and lies. She didn't give the child permission to say, I don't know, and she certainly didn't give the child permission to correct the interviewer if she said something wrong. All of these things we know detract from children's accuracy in situations like this. The child was asked during that interview a total of 46 suggestive questions, and she was exposed to a range of ancillary techniques that we know detract from accuracy, including free drawing, toys, and information from other sources were presented to the child during the course of her interview. That same child was interviewed more than 2 months later, and prior to that interview, there were numerous conversations between the child and her mother. The child was exposed to additional sex education material. She entered therapy. During the interview, again, the ground rules were not met. The child was asked a total of 18 suggestive questions, and she was exposed to free drawing, anatomically detailed dolls, and prior information was instantiated into the interview itself. This interview led to 2 charges against the defendant. So in short, this child was interviewed after very long delays. She was exposed to multiple sources of information that could have contaminated her evidence. And during the evidential interviews themselves, she was asked multiple suggestive questions and exposed to a range of interview techniques that have been shown to interfere with children's accuracy. Here's another example, so you can sort of get the picture here. Again, this child was interviewed more than a year after leaving the creche. Prior to the initial evidential interview, the child was exposed to multiple sources of information that could have contaminated their evidence. This is the timeline for the child whose mother engaged in the allegation simulation in the bath and constructed the booklet with her child. And during the interviews, once again, the child was asked multiple suggestive questions and exposed to a range of interview techniques that have been shown to compromise children's accuracy. This child's allegations led to 4 charges against Mr. Ellis. I won't go through in detail the other 2 children that I want you to show you, but I do want to highlight the fact that this is child 5 and child 6 that are going to come back to play a very important role in this case. Once again, children were interviewed over very long periods of time, exposed to multiple sources of contamination, interviewed multiple times. Many of the interviews were not shown in court, and the interviews themselves were flawed in a number of different ways. So this is child 5, and similarly child 6, who was the child who I think did receive the most interviews. So this child was interviewed a total of 6 times. Only 4 of the interviews were shown in court. But nonetheless, between the interviews, the child was exposed to multiple sources of information, and the interviews themselves fell short on a number of different grounds. Now, as we continue to look through the materials, we noted a number of other things, and one of them was that there was also a not infrequent or not rare occasion where the interviewer showed total disregard for the child's answers. And I'll just give you a couple of examples here. The interviewer said, "Was it in the circle or somewhere else?" And the child said, "Oh, well, it was somewhere else." Right, so in the circle. Or this one, "And you told stuff to X and you finished tell me that stuff about Peter." The child engages in some baby talk, and the interviewer says, "Peter doing wheeze and things?" "Yeah, that wasn't really true." "And where he did it?" "No, that wasn't really true." And the interview continued. Now, I'd like to say that these were the only examples. They weren't. And again, you can draw your own conclusions about what interview techniques like this might mean for the veracity of the children's accounts. So given the complex nature, hopefully I've indicated to you that this was a very complex case, and it was very complex in terms of memory. And given the complexity, it was really important for the jury to understand both the strengths and the limitations of children's evidence in court. Now, 2 experts did testify during the original High Court before the jury. One of them, Dr. Karen Zealand, she's already played multiple roles in this saga so far. She was also the Crown's expert witness, and the other expert was Dr. LePage, who testified on behalf of the defense. Now, both of these experts, as I said before, were psychiatrists, and none of them were experts in memory. And certainly in my reading of their testimony from the trial transcripts, the jury received absolutely nothing that could have possibly helped them make their way through this complex case. There was no discussion about the intricacies of the kinds of things that can influence children's memories. Both experts provided information, on both sides provided information that was incomplete or incorrect. For example, Dr. Zealand told the jury that children are likely to provide more information when they are asked direct questions or when they are presented with props, anatomical dolls, or allowed to play or draw. The problem was that what Dr. Zealand did not tell the court was that that additional information in response to those techniques also comes at the cost of a decrease in the accuracy of the children's accounts. Dr. Zealand also told the court that children were as good as adults in identifying the source of their memories. This is absolutely incorrect. And she told the jury that it is rare for children to provide a spontaneous and plausible account of completely fantastical events or events they've only heard about. Once again, the research literature shows that she was fundamentally incorrect. Anyone who's had a child didn't need Dr. Zealand to tell them about this. Dr. LePage also, although he was presumably on the side of the defense, he also gave the jury incorrect information about memory. Throughout his testimony, he misdescribed the concept of childhood amnesia. He also talked about repression, a phenomenon that's completely devoid of any empirical evidence after more than 100 years of research. He told the jury that it was possible for people to retrieve accurate memories following head injury by the use of hypnosis. This information was not only wrong, it was completely irrelevant to the Ellis case, and I suspect it left the jury absolutely bemused about what they were to take of Dr. LePage's testimony. Now, perhaps in the course of all of this, the most damning evidence that I uncovered during our investigation into the original trial was a letter that was written by Karen Zealand. Now remember, Dr. Zealand played many roles during this trial. She advised the police and the parents. She supervised the evidential interviews and then provided commentary in court about how good those interviews were. She provided evidence in the court regarding the use of a number of techniques. She provided evidence under the 23G provision. Now, during her testimony in the High Court, she absolutely categorically dismissed concerns about the opportunity for contamination prior to the evidential interviews. Now, many, many years into my work on this case, digging through the boxes of evidence that were stacked in my office, I located a letter that was written by Dr. Zealand to Detective Sergeant John L. And this is an excerpt from that letter. It is clear that child 6 parents elicited disclosures of abuse by Peter Ellis by highly leading questioning. Child 5's brothers and parents did the same. In Child 5's case, the parents subjected him to intensive interrogation pertaining to ritual abuse between the 3 August interviews, which were on consecutive days. Child 5 would then disclose in the next interview with Society the information elicited by his parents the previous night. This letter directly contravenes Dr. Zealand's sworn testimony at trial. And more importantly, perhaps, this letter was never made available to the defense at the time of the trial. So, what did the Supreme Court make of the grounds that Mr. Ellis's team put forward? They clearly agreed that there were multiple opportunities for the children's accounts to be contaminated prior to the evidential interviews, and in fact, they raised concern that was sufficient that there was potentially a miscarriage of justice in this case. They also agreed that there was poor evidential interviewing in the case, that the questions were not always appropriate, that there were props and dolls were used. But they actually concluded, and correctly, which is what I concluded in my brief, that it didn't really matter by the time you got to the evidential interviews whether the children were interviewed properly or not. By the time that first evidential interview happened, their memories were so contaminated that not even the best gold star interview in the world would have rendered their accounts accurate. They also agreed that the memory experts in the original trial were not particularly helpful in elucidating some of the complexities in this case. They also had a lot to say about 23G, and once again, that testimony was provided exclusively by Dr. Zealis. The court was very concerned that Dr. Zealis had well overstepped her bounds with respect to drawing a causal link between particular behaviors that the children demonstrated and providing veracity that they had in fact been abused, and keeping in mind that many of the behaviors that the parents were describing were also common behaviors of childhood, like bedwetting and fear of the dark and school refusal. So the court has come down very hard on Dr. Zealis with respect to her testimony in 23J. They did not agree that the sanitation of the charges led to a miscarriage of justice by Mr. Ellis, and we can talk about whether or not I agree with them on that point during the discussion. And they also did not agree that the fact that the jury did not see the full corpus of evidential interviews, that led to a miscarriage of justice. But they did very clearly agree on the basis of the evidence presented to the Supreme Court by Professor Don Elder, who is a forensic pediatrician, that the medical evidence that was provided in the court was absolutely wrong. So, the judgment of the court, the appeal hearing happened in October of 2021. The decision was rendered in October of 2022. These three simple statements was essentially what we were all waiting for. The application to adduce further evidence are granted, the appeal is allowed, and the convictions of the appellant are quashed. And thank you.